In today's complex marketplace, consumer protection laws serve as the vital safeguard between businesses and shoppers. These regulations ensure fair treatment, honest advertising, and quality products, while providing mechanisms for redress when things go wrong. With an astounding £106 billion in UK consumer spending, at risk from scams annually, the importance of robust consumer protection has never been more evident. This presentation examines the intricate relationship between sales practices and consumer rights, exploring how legislation protects the public while fostering healthy markets. The journey of consumer protection in Britain represents a fascinating evolution from rudimentary market regulations to comprehensive frameworks. What began as basic trade protections in Victorian England transformed dramatically during the consumer rights movement of the 1960s, culminating in landmark legislation that continues to shape today's retail landscape. The scale of consumer issues in the UK marketplace underscores why robust protection frameworks are essential. With 1.4 million formal complaints filed annually, consumers face significant challenges navigating an increasingly complex marketplace. Financial vulnerability has grown substantially, with the Financial Conduct Authority reporting a troubling 43% surge in financial fraud since 2020. These statistics reflect broader market dynamics, where consumer confidence and economic health depend on effective regulatory safeguards. At the heart of sales law lie three fundamental principles that establish the legal relationship between buyers and sellers. Contract formation requires a clear offer, definitive acceptance, and valid consideration, creating the binding agreement upon which all transactions rest. Statutory implied terms, embedded in legislation like the Sale of Goods Act 1979 and Consumer Rights Act 2015, automatically insert critical protections into every consumer transaction, regardless of whether they're explicitly stated. These principles work together to create a foundation of fairness and transparency in the marketplace. The modern UK consumer protection landscape is built upon several cornerstone pieces of legislation. These laws work in concert to create a comprehensive safety net across all transaction types, from traditional retail to digital marketplaces. The type of contract formed between buyer and seller dramatically affects the rights available to consumers. Business-to-consumer, B2C transactions receive substantially greater protection than business-to-business, B2B dealings, reflecting the inherent power imbalance between experienced businesses and individual shoppers. The UK's regulatory landscape is a complex system with overlapping jurisdictions, creating a comprehensive enforcement network. The Competition and Markets Authority serves as the primary market watchdog, while trading standards officers operate at the local level to address immediate consumer concerns. In the financial sector, the Financial Conduct Authority maintains strict oversight, particularly given the complexity and risk associated with financial products. This multi-layered approach ensures protection across all market segments and transaction types. Unfair trading practices can severely damage consumer trust, with the average annual loss rising £20 million in fines during 2023. These deceptive practices not only harm individual consumers, but undermine market confidence and competition. The right to cancel represents one of the most valuable consumer protections in modern sales law. Under the Consumer Contracts Regulations 2013, shoppers enjoy a 14-day cooling-off period for online and doorstep purchases, allowing them to change their minds without penalty. This protection led to over £460 million being refunded to UK consumers in 2023 alone. While consumers typically bear return shipping costs, businesses must process refunds promptly, generally within 14 days of receiving returns or cancellation notice, and often before goods have been dispatched. The UK maintains alignment with the EU's 2-year minimum guarantee period despite Brexit, ensuring consumers receive consistent protection for faulty goods. This statutory guarantee exists alongside, rather than in competition with, any voluntary warranties offered by businesses. Faulty goods generate over 60,000 small claims annually in the UK, highlighting the importance of this protection framework. When services fall short, similar rights apply. Consumers can demand repeated performance or price reduction if the service isn't completed with reasonable care and skill. The digital marketplace presents unique consumer protection challenges that traditional frameworks struggle to address. When digital content generates consumer issues, additional compensation rights extend beyond the content itself, covering repair costs or replacement of faulty hardware. Online retailers must ensure digital products remain accessible for reasonable periods and maintain backward compatibility where appropriate. These obligations reflect the growing importance of digital purchases in consumer spending. Consumer fraud has reached alarming levels, with Action Fraud reporting £2.6 billion in total losses during 2023. According to recent FCA research, 78% of UK adults now express significant concern about scams, reflecting growing awareness but persistent susceptibility. Online shopping fraud leads the categories with £620 million in annual losses, followed closely by banking fraud and investment scams. These figures highlight the critical importance of both regulatory protection and consumer education in the digital marketplace. A recent high-profile crackdown in the hotel sector addressed the growing practice of undisclosed resort fees and facility charges. Similar investigations have targeted the entertainment ticketing industry, where service charges and processing fees often add substantial costs revealed only at checkout. These enforcement actions reflect the regulator's focus on drip pricing as a priority consumer protection issue. The UK's product safety framework, centred on the General Product Safety Regulations 2005, establishes the fundamental expectation that all consumer products must be safe under normal or reasonably foreseeable conditions of use. This overarching obligation is supplemented by product-specific regulations for high-risk categories. The system's effectiveness is evident in the over 5,000 product recalls issued in 2023 alone, preventing dangerous items from causing consumer harm. Manufacturers and importers bear primary responsibility for ensuring that products meet safety standards, while regulators must not supply products they know or should presume to be unsafe. Recent regulatory focus has targeted misleading environmental claims through the Green Claims Code, addressing the growing problem of greenwashing, where products exaggerate their sustainability credentials. Companies must now provide evidence for any eco-friendly assertions before making marketing claims. The regulatory framework balances access to credit with safeguards against exploitation and over-indebtedness. Consumer credit protections acknowledge the particular vulnerability consumers face in financial transactions, where complexity and long-term commitments create significant risk. The UK's redress landscape offers consumers multiple pathways to resolve disputes without resorting to expensive litigation. These mechanisms not only provide swift relief, but generate valuable data on systemic market problems that inform regulatory priorities. Effective enforcement remains essential to ensuring consumer protection laws deliver meaningful change. The UK's diversified enforcement approach combines civil and criminal mechanisms with varying levels of severity to provide proportionate responses to breaches of consumer law. Landmark cases illustrate important precedents while sending powerful messages to markets about regulatory priorities and enforcement risk. The British Airways GDPR fine of £183 million represented the first major penalty under strengthened data protection rules, highlighting growing focus on digital consumer rights. Meanwhile, the Volkswagen emissions scandal settlement demonstrated the ability of collective consumer action to secure redress even against powerful corporations. These cases underscore the critical role of enforcement in maintaining consumer trust and market integrity. The UK's regulatory landscape has evolved significantly post-Brexit, gaining autonomy to chart its own course. While the UK Digital Markets Unit offers a more tailored approach, the EU's GDPR continues to influence UK consumer protection. This nuanced approach balances consumer protection with business interests, ensuring a pragmatic alignment with European standards. Technology is reshaping consumer rights, with AI sales techniques and deepfakes presenting new challenges. The FCA is actively reviewing fintech risks, while data privacy remains a critical concern. As technology advances, it is crucial to address these emerging vulnerabilities to protect consumer interests. Consumer education campaigns like Know Your Rights play a vital role in empowering individuals to understand their legal entitlements. Organisations such as Citizens Advice translate complex legal frameworks into accessible guidance, helping consumers navigate their rights effectively and make informed decisions. The consumer protection landscape faces challenges from AI-driven sales and subscription traps to sustainability claims and regulatory agility. As businesses innovate, it is essential to address these issues to ensure consumer welfare and adapt to emerging digital business models. Trust between businesses and consumers is foundational for a fair marketplace. The UK's evolving consumer protection laws aim to balance competition with robust safeguards, ensuring fair markets and fostering trust. This ongoing calibration ensures a dynamic and fair consumer economy.